Can you go to jail for a DWI on Long Island? Yes, you can go to jail for a DWI conviction on Long Island under New York Vehicle and Traffic Law Section 1192. A first offense DWI is an unclassified misdemeanor that carries up to 1 year in jail, although jail time is not mandatory. Repeat offenses, a high blood alcohol content, and other aggravating factors can increase the likelihood and length of a sentence. New York treats DWI as a criminal offense rather than a simple traffic ticket. Even a first conviction can lead to fines, a license revocation, and a permanent criminal record. A first DWI under VTL Section 1192(2) or 1192(3) may bring a fine between $500 and $1,000, up to 1 year in jail, and a minimum 6-month driver's license revocation. The court must also impose probation or a conditional discharge, and the sentence must include installation and use of an ignition interlock device on any vehicle the driver owns or operates. A second DWI offense within 10 years is a Class E felony punishable by up to 4 years in state prison and fines between $1,000 and $5,000. A third DWI offense within 10 years is a Class D felony punishable by up to 7 years in prison and fines between $2,000 and $10,000. An aggravated DWI based on a BAC of 0.18% or higher carries more serious penalties, including a minimum 1-year license revocation. DWI with a child passenger age 15 or younger is a Class E felony under Leandra's law, even for a first-time offender. There is no mandatory minimum jail sentence for a first DWI, but a judge may still impose incarceration based on the facts of the arrest. Judges look closely at the driver's BAC level when deciding whether jail is appropriate. Prior DWI or DWAI convictions within the past 10 years also significantly increase the risk of jail time. Other aggravating factors include causing an accident, having a child passenger, driving with a suspended or revoked license, refusing a chemical test, or speeding excessively. Most first-time DWI charges begin as misdemeanors, but certain circumstances can elevate the case to a felony with far more serious consequences. If a DWI causes serious physical injury, the driver may face vehicular assault charges, and if it causes death, the driver may face vehicular manslaughter charges. An arrest does not automatically mean a conviction, because several defenses may apply depending on the facts of the case. A lawyer may challenge whether the officer had reasonable suspicion to make the traffic stop in the first place. A DWI lawyer may also challenge breathalyzer results if the device was not properly maintained or the officer was not currently certified to administer the test. Field sobriety tests can also be questioned because they are subjective and may be affected by medical conditions, weather, road surfaces, or nervousness. An attorney can also challenge the officer's observations, including claims about bloodshot eyes, slurred speech, or the smell of alcohol. After a DWI arrest, the driver is usually taken to a local police station for booking and processing before arraignment. At arraignment, the judge informs the person of the charges, addresses release or bail conditions, and may suspend the license pending prosecution when the statutory requirements are met. A conditional license through the DMV's Impaired Driver Program may allow limited driving for work, school, medical appointments, probation, and certain childcare needs, depending on eligibility. Attorney Jason Bassett has defended DWI cases across Suffolk County and Nassau County for over 2 decades, and this law firm handles challenges to the stop, negotiations with prosecutors, and trial representation. For guidance from the law offices of Jason Bassett, PC, call this law firm at 631-259-6060 or visit the office at 320 Carleton Avenue No. 4200, Central Islip, New York, 11722, United States.